Hello everybody, I welcome you all again. We are still under the Constitution section of our polity. Let's revise chapter 3 of the Indian polity Lakshmikant. This is the chapter 3 of Indian polity Lakshmikant, the salient features of the Constitution. Let's quickly go through this and complete this chapter in the very small span of time that we can. And it's a very small chapter, and I don't think that we would be taking more than 20 or 25 or 30 minutes. Let's quickly go through it. See, when we first come to introduction, see, Indian Constitution is unique that we know, but it is borrowed from almost every constitution of the world, but in its origin, it is actually the innovation of the founding fathers of our Constituent Assembly. Then there are features of the Constitution. However, these features have undergone a substantial change in various amendments, of which big ones were 7th, 42nd, 44th, 73rd, 74th, 97th, all of these. And out of this, the 42nd amendment is called a mini constitution. Why? Because it had important and large number of changes made by it in various parts of the Constitution. Also, in Kesavananda Bharati case, Supreme Court ruled that the constituent power of the Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. We'll go through this chapter again, which is there itself in Indian polity, and then we'll know what are the things that fall under basic structure of the Constitution, which according to Article 368, the Parliament cannot enable it to alter. Let's again quickly see what all were there in 42nd Amendment Act, which makes it to be a mini constitution. We have come to Appendix 6, Constitutional Amendments at a glance, and we'll quickly go through the 42nd Amendment Act that is there, so that we know what makes it a mini constitution. See, first of all, we already read in the preamble that SSI, the Socialist, Secular and Integrity part in the preamble, was added by the 42nd Amendment Act, which makes it a mini constitution. So what were the next things? See, it added fundamental duties. Initially, our constitution had just made FR and DPSP, but fundamental duties were added by the 42nd Amendment Act. Then it made the president bound by the advice of the cabinet, which was there under precedent. We'll see, it's already there in the video. And it made the constitutional amendments beyond judicial scrutiny, which is something that made the dispute between the judiciary and the legislation go further. Then it curtailed the power of judicial review. We'll see to this. New directive principles, it was there in emergency. It somehow discussed over the list, or the subject list, the concurrent list, the union list, and it provided for the creation of the All India Judicial Services. It empowered the Parliament to do something. So we'll see that 42nd Amendment Act had somehow had amendments over all the spheres in the Constitution. So it was also called a mini constitution because it brought numerous changes that wasn't actually required, but that created a lot of controversy also, and this was done in the Indira Gandhi government time. Let's get back to this video. See, one is the features of the Constitution that we are going to see, and then after features we complete one portion of this chapter, and then there are the Constitution of India at a glance, which has the parts and the articles and the subjects and whatever things that come in the matters, and then it also has important articles of the Constitution at a glance. And then we have the schedules. Initially there were 8 schedules, but today we have until here 12th schedule. So we'll see what all schedules are here, and then from where have been taken a lot of points which comes under the Constitution, from where have we taken. So the sources of the Constitution at a glance is also given in this chapter, and then we'll also see the criticism of the Constitution. In yesterday video we saw the criticism of the Constituent Assembly, and today we'll see the criticism of the Constitution, and we'll see what is the difference or what is the similarity between them. Let's get started with our first point. See, in the features of the Constitution, see, our Constitution is considered as the lengthiest written Constitution. First of all, there are oral constitutions and written constitutions, and we have a written Constitution, and we have it as the lengthiest. Why? Because American Constitution is written and British Constitution is unwritten. So in this case we follow American Constitution, and it's the lengthiest, and the Constitution is the lengthiest of all the. It is a very comprehensive, elaborate and detailed document, and we actually saw in the criticism of the Constituent Assembly when it was said that it is a lawyer politician domination, and that is why it was the reason for the bulkiness in the complicated language of the Constitution. So from this criticism point we can get the first point of the features of the Constitution, that is, it is the lengthiest written Constitution. So we see that initially it had 395 articles and 8 schedules, and today it has more than 465 articles and then 12 schedules. Also, 4 factors that have contributed to the size is, see, India is diverse, so we have to see to the religious matters, to the linguistic matters, to the minority matter, and a lot other things. Historical factors, there have been numerous history and numerous laws made in the history which actually would have been practical, and we would have wanted to implement it through us into our constitution. So this is historical factors which is important. And then single constitution we actually require for both the center and the states, and for to make the single constitution in this diverse nature, there had to be a lot of articles that was required to make it the single constitution, but worth to be taken by everybody and accepted by everybody. However, Jammu and Kashmir until now had a different constitution, but this year itself we have it changed, so we'll go through this in another video. And then dominance of legal luminaries in the Constituent Assembly. Also, now Constitution contains not only the fundamental principles of governance but also detailed administrative provisions. So we actually can say, when Supreme Court said that preamble can be referred to as the as a guidance or a book that we can actually refer to when we want to take suggestions over a case, we can mean actually this, that because it also contains the detailed administrative provisions of how to actually govern and not just what to govern. Then we have drawn from various sources. See, it is drawn from various sources, and we will see that is the structural part is derived from the Government of India Act of 1935, which is given in chapter 1. We will see, we had the Government of India Act of 1935, and we'll go through this when we actually go through our first chapter. But today we can see that the structural part of the Constitution is derived from the Government of India Act of 1935. Then the philosophical part is from that is the fundamental rights, the directive principles that actually derive the philosophy of our Constitution is from American and the Irish Constitution respectively. So this is from Irish and this is from American. Then we have the political part, which is actually the British Constitution, because there were a lot of articles that actually British people had helped us in making up, and then we finally decided that this has been the essential part of our Constitution. Then we have blend of rigidity and flexibility. See, a rigid constitution is what? Where a special procedure is required for its amendment, which is American Constitution. Flexible is anything can be amended in the British Constitution. But we, like all the time, Indians have wanted to be the balance between the extremes and the extremes. We've had the blend of rigidity and flexibility. Why? Because there are times when amendment can be flexibly made, and there are times when amendment is very rigid to be passed by. So we have the first is special majority, where 2/3 majority of each house present and voting and a majority of the total membership of each house is required. This is special majority. And then we have the special majority also in which the ratification by half of the total states is required. And one is that we call as simple majority. So we have special majority, we have special majority with ratification of the half of the states, and then we also had the simple majority. These all come under the Article 368. And then we have federal system with unitary bias. See, again we'll see that usual features of the federal system is what? A written constitution, two government, division of powers, and then supremacy of the constitution, rigidity of the independent judiciary, and bicameralism. We all have this. However, with this, we have a strong center, we have a single constitution, we have a single citizenship, we have flexibility of constitution, we have integrated judiciary, and we actually appoint the state government by the center, and all India services is also there, emergency provisions is also there. So we will see that actually our constitution is federal. There are rights given to states, but with that right comes the unitary bias, that is center always plays a major role in the working of our constitution. And then we also see that Indian federation is not the result of an agreement by the states, that is no state has a right to secede from the federation. So this is also there in the 4th chapter, we will see, but I can show you now itself. See, we are here in the 5th chapter, the union and its territory. We will do this in another video, but I just wanted to show you a part where it's written that India is an indestructible union of the destructible states. So it's an independent country, but an indestructible union of destructible states. That is, the state can be destroyed, but the union in itself cannot. See, the union governments can destroy the states, whereas the state governments cannot destroy the union. How? See, in USA, the territorial integrity or continued existence of a state is guaranteed by the constitution. And they have double citizenship, we have single citizenship here. So USA is called the indestructible union of indestructible states, but here the states can be destructed, the states can be divided or united, but union cannot be adjusted or ratified or anything. So we see that India is actually the indestructible union of destructible states. Now coming to the 5th point, see, we have parliamentary form of government, and what are the features in the parliamentary form of government? We'd already seen it yesterday. Let's quickly go through that. See, when we were doing the chapter preamble, under the part democratic, we'd seen that we have the representative parliamentary democracy, and we saw what were the features there, that is universal adult franchise, periodic elections, rule of law, independence of judiciary, absence of discrimination on certain grounds, and the democratic character of the Indian polity. These are all the features of parliamentary democracy that we'll again see. So we can see here that the Constitution of India has opted for the British parliamentary system, whereas American is the presidential system. So the parliamentary system is based on the principle of cooperation and coordination between the legislative and executive organs, where one formulates the policies and the other implements the policies, while the presidential system is based on the doctrine of separation of powers between the two organs. There the legislative, judiciary and the executive is not related to each other. And the parliamentary system is also known as what? Westminster model of government, where we have responsible government and cabinet government, and the this is also called responsible government and cabinet government. Why is it called responsible government? Because executive is always responsible to the legislature for its working, and the cabinet government because we have cabinet ministers in this constitution. Also, the constitution establishes the parliamentary system not only at the center but also in the states. The features of the parliamentary we've already seen. Let's quickly go through them also. See, there is nominal and there is real executive. How? Nominal is now the president, the titular one, and the real is the prime minister that we already have. But in presidential system, we see that the nominal and the real both is the president. Then we have majority party rule. Whoever has the majority, their leader becomes the prime minister. So accordingly, majority party rule is there. And then we have collective responsibility. Why? Because executive is collectively responsible to the legislature for its working. Then we have membership of the ministers in the legislature, leadership of the prime minister or the chief minister, and then dissolution of the lower house, Lok Sabha or the assembly. So if there is no confidence, we can actually dissolve the Lok Sabha. So this is again the responsible government that we see. Thus, Indian Parliament is not a sovereign body like the British Parliament, and the Indian state has an elected head, that is republic, and not the British state like hereditary thing that they have it there. And in a parliamentary system, whether in India or Britain, the role of the prime minister has become so significant and crucial that more or less we can call it a prime ministerial government also. Then we have synthesis of parliamentary sovereignty and judicial supremacy. See, parliamentary sovereignty is the idea of the British part and the judicial supremacy is the American part. But we have a blend of both. How? Because the scope of judicial review or the power of the Supreme Court in India is narrower than that of what exists in US. So the American judicial supremacy is the most and the highest. But we have this concept but at a narrower level than the US part. And then the American Constitution provides for due process of law against that of procedure established by law contained in the Indian Constitution. If you already know this, do comment down what do you mean by the due process of law and the procedure established by law. However, when we do basic structure of the Constitution, we'll have a detailed analysis over these two words. Then, the framers of the Indian Constitution have preferred a proper synthesis. So, the Supreme Court on one hand can declare the parliamentary laws as unconstitutional through its power of judicial review. However, the Parliament on the other hand can amend the major portion of the Constitution through its constituent power. So, it's not just that Supreme Court has to rule everything, and it's not just that Parliament can keep working and no one is there to control this Parliament. So, it's the synthesis of both the Supreme Court and the Parliament, both the judiciary and the parliamentary sovereignty. And then we have the integrated and independent judiciary. How? See, Supreme Court stands at the top. So, the independency is there. They are not liable to answer to the executive or the legislature or the parliament or anybody. And the high courts at the state level are there. So, it is an integrated form. The Supreme Court is at the top and then we have high courts and then high courts have the district courts and accordingly we keep going. Then, in USA, what happens is both the central laws as well as the state laws, unlike in USA, where the federal laws are enforced by the federal judiciary. See, in USA, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. However, the Supreme Court is a federal court for us, the highest court of appeal, the guarantor of the fundamental rights of the citizen and the guardian of the Constitution. Hence, the Constitution has made provisions to ensure its independence. How? We'll see in the Supreme Court chapter and the High Court chapter that security of the tenure of the judges, fixed service conditions, all of these make sure that the Parliament cannot use the advice of the Supreme Court or the portion of the Supreme Court to their advantage. So, the independence, the judiciary is independent of this Parliament or the Constitution. Then we have fundamental rights. See, part 3 of the Constitution is the fundamental right and part 4 of the Constitution we'll see is TPSP. And under this only we now have fundamental duties also, which we just saw that was added by the 42nd Amendment Act. So, fundamental rights we have right to equality, freedom, right against exploitation, freedom of religion, all of these. We'll actually go through this when we do the chapter fundamental rights. So, fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. We'll actually go through this in very detail and doing the complete analysis of this. But for now, let's just have it in a small view so that we can actually know and we are not unanswerable to people if we are asked about what is fundamental rights. And fundamental rights are not absolute. They are not subject to reasonable restriction. We'll actually go through all of these terms, what do they mean and everything. So right now, we just have to know that fundamental rights is one of the feature of the Constitution and the same is the DPSP here, which has socialistic, Gandhian and liberal intellectual parts. And then we have fundamental duties, which is actually added by 42nd Constitutional Amendment Act that I already said. Then India is a secular state and there are a lot of points that you can see here that secular state, India does not uphold any particular religion in the official religion of the Indian state. We'd actually seen this in the preamble chapter when we were actually going through the secular point of the preamble, which is in page 4.2 of the 5th edition of Indian Polity Lakshmikant. So we can see that the secular state is here, and secular was added by the 42nd Constitutional Amendment Act in the preamble. We know this. Preamble secures to all citizens of India the liberty of belief, faith and worship. We know this. This Article 14 is here, Article 15, Article 16. All of this is under the fundamental rights that we'll go through. So if you want to just read and understand, you can. Otherwise, when we actually complete the fundamental rights and we revise that, we'll see what all these articles are and how do they actually define the freedom of our constitution. Then universal adult franchise is something everybody knows, so we can just avoid this. We can just note down that voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. Let's quickly go through the amendments part and see which was the 61st Amendment Act and where is it written about the point which we actually went through. See, this is the 61st Amendment Act. See, it reduced the voting age from 21 years to 18 years for the Lok Sabha and state legislative assemblies, and the additional members were added to the Election Commission. See, so 61st Amendment Act, which is there in 1989, just had this one amendment that we can see in our chapter. Single citizenship is something that we both know. We all know that American Constitution has dual citizenship, whereas Indian Constitution has single citizenship. And we see that there are independent bodies which actually function according to the roles they are assigned with independently. Election Commission, free and fair elections to the Parliament, State Legislature, Office of President, Office of Vice President. We have CAG, they are the guardian of the public purse. We have UPSC, which actually recruit the All India services and higher central services. Then we have the SPSC, which are the recruitment agency of the states. And then this is it with the independent bodies, and then we have the emergency provisions. This is a complete different chapter, which is a very, very important chapter, and we'll go through that chapter and we'll see what are the kinds of the state emergency and what are the articles and what happens actually when we have the emergency provisions. It enables the president to meet any extraordinary situation effectively. Then we have three-tier government. How is it a three-tier government? We have the center, we have the states, and we have the local. How did it become local? It started with the 74th Constitutional Amendment Act. The 73rd Amendment Act actually gave the recognition to the panchayats, and then the third tier of government was actually part of the constitution. And then we have the constitution recognition to the municipalities also. We can see here that the parts here that the Constitution of India at a glance that we have. The part 9 here is panchayats, which are actually added by 73rd Amendment Act, and the 9A, part 9A, municipalities, were added by the 74th Amendment Act. Let's quickly go through the amendment part and see whether what we are studying is correct or not. See, when we come to the amendment page, we'll actually see that the 71st and the 73rd and 74th Amendment Act are here. See, 73rd Amendment Act says that the granted constitutional status and protection to the Panchayati Raj Constitution, and then part 9 was added and the 11th schedule was made. And then we have the 74th Amendment Act, which says that constitutional status and protection to the urban local bodies, part 9A, and then it was added to the new 12th schedule that was there. So we actually see that the part 9 and part 9A was there, and we can also see the schedule part here. We'll see the 11th schedule. We'll see it specifies the powers, authority and responsibilities of Panchayat, and this schedule was added by the 73rd Amendment Act. And then the 74th Amendment Act, the municipalities, is the 12th schedule, and we initially had up to the 8th schedule. So this is it with the features of our constitution, and then this is the subject matter. This is the Constitution of India at a glance, where we have all the articles and all the citizenships and every point that is there in the constitution in the very summarized detail that we have here. And then we can also see that there are important articles of the constitution at a glance that you can actually refer to when you're actually wanting to write some articles in your answers. And then you have the schedules of the constitution at a glance, the first schedule, second schedule, and all of this. See, the complete detailed video of this, we'll actually not be doing it today right now, because this would increase our chapter, and this is something that we keep revising. So I'll make a different set of videos so that we can have the shortcuts to it and understand and mug up everything of this schedule altogether. And I will be including the sources of the constitution at a glance in this video itself. So let's quickly move to the 17th point of the features of the constitution, that is cooperative societies. See, this was again added by the 97th Constitutional Amendment Act of 2011, which was initially not there, but now it's there. So let's quickly go through the amendments part of the Constitutional Amendment Act and see which 97th Constitutional Amendment Act talks about the policy of the cooperative societies that was there. See, 97th Amendment Act in 2011, constitutional status and protection to cooperative societies, included Article 19, Article 43B and 243ZH to 243ZT. So this makes our constitution the bulkiest constitution. So criticism is what? See, it's nothing indigenous, it's a borrowed constitution, so we can know that this is it. It's a carbon copy of the 1935 Act. When we see the Government of India Act 1935, you will see that most of the points that are taken into the constitution is from that Government of India Act 1935. Then we see that it is un-Indian or anti-Indian. Why? Because it does not reflect the political traditions and the spirit of India. it has the foreign nature, that is some parts of the American Constitution and the British Constitution. And then it is an un-Gandhian constitution. Why? Because it does not contain the philosophy and ideals of the Mahatma Gandhi, who actually opined that the constitution should have been raised and built upon village panchayats and district panchayats, whereas we can see that panchayats was something added by the 73rd Constitutional Amendment Act, and which was initially not there also in a part of the constitution. Elephantine size is something that we all know, it is too long and complicated, and we know when it was criticized in the Constituent Assembly part that why is it actually too long and complicated. And then we have again here the paradise of the lawyers, because the words here are too legalistic and very complicated, and it's also called a lawyer's paradise by Sir Ivar Jennings. So this is it with our chapter. We will go through this in the new video that I make about the schedules of the constitution and sources of the constitution, and we'll revise this portion there, and thus we are done with the chapter 3 of the constitution. So until now we have completed the chapter 2, chapter 3 and chapter 4 of our constitution. So 1 is done, 2 is done, 3 is done and 4 is done. These 3 chapters are over. We'll quickly go through the first chapter. That's another video, but that's going to take time, so I'll make it a little later. Let's see what happens to the next chapter. But we still have a long way to go before we actually complete the constitution. So let's meet quickly in the next video. Thank you for watching. Keep studying until then.